A entrusts her property to her husband, which she received as gift from her parents. The husband and his relatives converts it to their own use. Would the husband and the relatives be charged of any offence? If at all it could be an offence, it could be either criminal misappropriation or criminal breach of trust. Seemingly the same, isn't it? But they are not. There is a very narrow line of distinction between these two offences. Today we shall take up this topic when we closely analyze criminal breach of trust dealt with under section 405 of the Indian Penal Code. We shall look into the essential ingredients of the offence constituting criminal breach of trust, the punishment which is provided under section 406 IPC, and finally the activity session. Welcoming you all to Law Cities, the mini law lecture series. The meaning, or rather the definition of the offence of criminal breach of trust is provided under section 405 of the Indian Penal Code. And going by the provision, the essential ingredients of the offence are: the accused must be entrusted with the property, he has misappropriated or disposed it of in the violation of the trust, and the entire transaction was with dishonest intention. If all of these could be proved, then the offence is definitely criminal breach of trust. Alright, so now let us analyze the essentials of criminal breach of trust in the actus reus and mens rea perspective. Misappropriation of entrusted property happens to be the requisite actus reus for the offence of criminal breach of trust, while dishonest intention is a requisite mens rea. Got it? Thus, entrustment is a key ingredient of the offence of criminal breach of trust. So now let us look into the meaning and scope of the term entrustment in section 405 IPC. When a property is handed over from one person to another person for a specific purpose, then we say that the property is entrusted to the latter person. And as far as section 405 is concerned, it extends to all kinds of entrustments, whether it be express or implied. But here again, how do we ascertain whether there was an actual entrustment of property or not? The yardstick or the criteria for determining whether the accused has actually been entrusted with the property or not is to check whether he is holding any possession of trust with the victim. And if the answer is yes, then he is entrusted with the property, or else he is not. And usually we see such entrustments with clerks, servants, business partners, etc. Okay, so now on to the subject matter of the offence of criminal breach of trust. The terms of the provision is worded as in any manner entrusted with the property. It is to be noted that here the term property is not prefixed with any term, which means section 405 provides no restriction when it comes to the subject matter of the offence. It can be movable property or immovable property. Hence, any property which could be subjected to the acts covered by this provision would fall under the purview of property as per this section. Clear? Yet another major component of the offence of criminal breach of trust is dishonest misappropriation. You got to refer to section 403 IPC to understand what dishonest misappropriation is. Taking possession of a movable property and putting it to unauthorized or wrongful use with dishonest intention is dishonest misappropriation in simple terms. We have covered the offence in detail in our previous lecture. Please do refer to it so that you would understand criminal breach of trust better. Coming back to the mens rea component, which is dishonest intention. Time and again, courts have reiterated that mere mismanagement does not amount to criminal breach of trust. Only when the accused has dishonest intention, he could be charged with this offence. This mens rea element also we have covered previously. When a person intends to cause wrongful gain or wrongful loss, then the person is committing the act dishonestly. The intention with him is dishonest intention. Section 24 IPC provides for the definition of dishonestly, while wrongful gain and wrongful loss you will find in Section 23 of the Indian Penal Code. And finally, on to the punishment for the offence of criminal breach of trust. It is provided under Section 406 IPC, wherein the offender shall be imprisoned for a term extending to 3 years or fine or both. Alright, so now on to the differences between criminal misappropriation of property and criminal breach of trust. Entrustment of property is a key ingredient of the offence of criminal breach of trust, which is provided under Section 405 of the Indian Penal Code. Whereas there is no such entrustment of property in criminal misappropriation provided under Section 403 of the Indian Penal Code. Another area of difference is with respect to the subject matter of these two offences. The term property in criminal breach of trust is provided without any qualifications, which suggests it is used in a wider amplitude, including in it both movable and immovable property, which is not so in the case of criminal misappropriation of property, because the term movable is prefixed to property here and thereby narrowing the subject matter. And as far as the punishment is concerned, for criminal misappropriation, it is imprisonment extending to the term of 2 years or fine or both, while for criminal breach of trust, it may extend to 3 years or fine or both. Alright, so now on to the activity session. First problem. A servant had misappropriated the valuables of his master's house when the latter and his family went touring. What would be the offence charged against the servant? Here, the servant had misappropriated the master's property in his absence. Hence, superficially it seems to be criminal misappropriation as provided under Section 403 of the Indian Penal Code. But is it just that? If there is a confusion pertaining to the offence committed between criminal breach of trust and criminal misappropriation of property, the test to be applied is whether the property was entrusted to the accused. Put in other words, whether the accused was holding any position of trust with the victim. In the instant case, the servant is obviously holding a position of trust, isn't it? Especially in the absence of the master and his family. So, undoubtedly, there was entrustment of property onto the servant. And once he misappropriated that entrusted property, it becomes criminal breach of trust. Of course, there must be dishonest intention in this transaction, which very well could be read in from the facts of the case. When the facts state that the servant had misappropriated the valuables in the master's absence, dishonest intention is being evident. So, the offence charged against the servant is nothing but criminal breach of trust. Second problem. A entrusts her property to her husband, which she received as gift from her parents. The husband and his relatives converts it to their use. Would the husband and the relatives be charged of any offence? Let us first examine whether there is misappropriation involved here. Yes, the facts itself state that A's husband and his relatives had converted the property to their own use. So the misappropriation part is proved. Now let us see whether this offence could be criminal breach of trust or just misappropriation of property. But let me ask you here, why should we so carefully check whether it is criminal breach of trust or criminal misappropriation of property? It is because criminal breach of trust has got graver punishment than criminal misappropriation of property. So the defense always would wish to prove that the offence is criminal misappropriation of property, while the prosecution would always wish to prove that it is criminal breach of trust. I hope you got the point. Back to the instant case. To ascertain which of these offences had been committed here, you need to apply the test of entrustment. Whether the accused was holding a position of trust with the victim? Of course, husband obviously holds a position of trust, isn't it? And it was against the trust that he and his family members had misappropriated her property. So, he could definitely be charged for criminal breach of trust. And that's all we have for today's lecture. If you like the video, why don't you share it and click the thumbs up? And if you are new to Law Cities, please subscribe to the channel. Till we meet next, bye.